Good morning, everyone, and welcome to today's webinar on the latest changes in holiday pay and regulations. So just waiting for a few more people to join us, and we should get cracking. Let's just see. Excellent. So just to say, my name is Marie Pegram. I'm a partner at Recruitment Accountants, and it's an absolute pleasure to be your host today in today's session. And holiday pay can be a complete minefield. I've had many conversations at the end, I'm sure Paul has as well, on holiday pay, the impact it has on your margins, dealing with temporary workers, and also looking now actually at your permanent recruitment consultants as well. And it's really hard to know what's right, what's wrong, and especially with the latest changes that have come into play as well. So while many of the changes recently are focused on part-year and irregular hour workers, there's also some significant implications on possibly your in-house consultants and irregular commission as well. And that's why I'm really pleased to be joined today by employment expert Paul Chamberlain from JMW Solicitors. And Paul brings nearly 3 decades of employment law expertise. I'm sure Paul appreciates me drawing attention to that.
That's fine.
But in particular in the recruitment sector as well. So welcome, Paul. Thank you so much for joining us today.
You're very welcome. It's a pleasure.
Would you mind introducing yourself to our audience?
I will do that indeed. And most people are now shocked because when they look at me, they say, this guy can't have 30 years experience. It is, in fact, just over 30 years experience, which means there's very little that I haven't seen in this space. Just a little bit about me. So apart from my obvious age, I head up an employment team at JMW, which has around about 20 people in it. The whole firm has close to 800 staff and over 100 partners, and our head office is based in Manchester. But we've also got some offices in London and Liverpool. And my employment team does what you would expect a commercial law firm's employment team to do. It's a cradle-to-grave service, and indeed beyond, when we act for people on employment tribunal matters and restrictive covenant cases. So I hope what I say today will be of assistance to you, and happy to take some questions at the end.
Brilliant. Thank you, Paul. And it's great to have an expert on here that we can fire all sorts of holiday pay questions and hopefully get some answers from them. Just to let you know, Paul will be sharing a presentation covering the recent changes and the impact these will have on your temporary workers and consultants. He'll also address some of the questions that we've had that have been sent in beforehand, which include the factors that affect the 12.07% calculation and whether we need to include commission in your consultant's holiday pay. So we'll have a Q&A session following Paul's presentation. So please feel free to use the questions function on Zoom, and I'll put Paul on the spot at the end and we'll try and answer all the questions as much as possible. But if we don't get around to answering your questions, we will follow up at the end of this webinar with contact details as well, and we'll make sure that we give as much support as we possibly can. So without further ado, I'm now going to hand over to Paul, who's going to share his presentation on holiday pay.
Thank you very much. Okay, so we're going to talk about holidays and holiday pay. And the reason we're going to talk about holidays and holiday pay is because there has been some historic confusion around how holidays and holiday pay should be calculated, specifically for what I would term atypical workers. So in the recruitment space, that's temps, temps who don't have regular hours or only work for part of the year. And if we can move on to the next slide, please, Katie. This just explains how we've got here. And we have still, and I'll come on to why I say we have still some discrepancies in this area, but we've come from a position where there are some problems, or have been some problems, with the interpretation of the legislation, where we're talking about people in the recruitment space, temporary workers. The reason for that is holidays and holiday pay are regulated by 2 different bits of legislation. The working time regulations, which are UK regulations that are derived from the European Working Time Directive, they stipulate that people are entitled to a week's pay for a week's leave. When you say that quickly, it sounds like a really simple principle. It's then complicated by the definition of a week's pay And the definition of a week's pay is not set out in the working time regulations. Believe it or not, it's set out in a completely different piece of legislation called the Employment Rights Act. And the Employment Rights Act defines a week's pay by reference to two different concepts. The first is where someone has normal working hours. If you have normal working hours, a week's pay is calculated one way. If you have no normal working hours, and that will be most agency temps, but not all, then the calculation of holidays and holiday pay is different. And that discrepancy or that difference was exacerbated as a result of something ACAS did back in around about 2010, 2011. ACAS do normally provide some very helpful guidance notes, but what they did back then was they changed their position on the calculation of holidays and holiday pay, and they introduced the concept of calculating holidays and holiday pay by reference to a fixed percentage, and that percentage will be the percentage that you are all very, very familiar with, that you know and love, and which has now been codified in the new legislation that we're going to come on to. That was 12.07%. But prior to that, ACAS set out in their guidance that holidays and holiday pay in particular should be calculated by reference to looking at pay over a previous 12 or 13 week period and averaging it out to give you a week's pay. And interestingly, that's broadly where we've ended up again. But for a long time, it was advocating the 12.07% route as appropriate. Now, with the Employment Rights Act working with or alongside the working time regulations, and then the ACAS code or ACAS guidance principles that were in play, we ended up with a piece of litigation that resulted in a Supreme Court ruling a year or so ago. And most of you on this webinar will be very familiar with the case of Harper Trust and Brazel. And it was Harper Trust and Brazel that effectively prompted the change in the law that we're going to talk about in the remainder of the webinar. And I think it's very important that we, without going into too much detail about Harper Trust and Brazel, I just summarize the headlines for you, because you'll see why a change to the law was necessary following the Supreme Court's ruling. Harper Trust was a group of education academies, and Mrs. Brazel was a music teacher, a peripatetic music teacher, and she travelled around school to school giving music lessons. And some weeks she'd have lots of lessons, in other weeks she wouldn't have very many lessons at all, so her hours fluctuated. And most importantly, she obviously didn't do any work for the trust when she was on, when the school was closed and there were school holidays. Now, what happened in her case was that she was paid holiday pay prior to the ACAS guidance changing in 2010-11. She was paid holiday pay by reference to what she'd earned in the previous term. So it was all totted up and it was averaged out, and that gave the Academy Trust the value of a week's pay. So she was then paid that amount for every week's leave that she then took. When the ACAS guidance changed and suggested that a handy way of making the calculation would be to apply the 12.07% fixed calculation, she noticed that her holiday pay went down. So she'd been receiving broadly the same holiday pay prior to that, and then all of a sudden 12.07% was applied and her holiday pay reduced. So she scratched her head, asked questions, didn't get very satisfactory answers other than to say, well, we're now following the ACAS guidance. But she wasn't satisfied with that. So she took the matter to the Employment Tribunal, And the case went right the way through the legal system to the Supreme Court, and the Supreme Court gave its ruling. And there were two things, two main principles, two main planks of the Supreme Court's ruling, which I think are very relevant, and as you'll see, resulted in the change that we're about to come on to talk about. The first was that the Supreme Court said, even if you're only a part-year worker, which is what Mrs. Brazel was, she didn't work a full year, and even when she worked, she wasn't working a full week. So she was very much a part-year worker. The trust tried to argue that her 5.6 weeks entitlement to paid annual leave under the working time regulations should be prorated. So in other words, if she only worked for 3/4 of the year, she should only get 3/4 of 5.6 weeks paid leave. And what the Supreme Court said was, no, that prorating principle doesn't appear anywhere in the legislation. What it says is that every worker is entitled to 5.6 weeks paid annual leave. But it's important to make the point that 5.6 weeks doesn't mean 28 days in every single case, because someone's working week may not be 5 days. So the point the Supreme Court made was everyone's entitled to 5.6 weeks, but when that's translated into days, that will change depending on the proportion of the year or the proportion of the week that the individual works. You only get 28 days as 5.6 weeks paid annual leave if you're a full-time worker doing 5 days a week. If you work 2.5 days a week, you don't get 28 days. You still get 5.6 weeks, but that 5.6 weeks equates then to half of 28, which is 14. So that was a very important principle. No prorating of the 5.6 weeks. Everybody still gets it, but it will result in different days entitlements depending on the amount of time the individual works. That was the first principle. The second principle was, because the court was required to look at it, the second principle was that they concluded that applying an across-the-board 12.07% as the method of calculating the amount of pay for that 5.6 weeks was wrong. And in the vast majority of cases would be very wrong indeed. In fact, when they did the calculation in Mrs. Brazel's case and worked it back to a percentage, what she was actually entitled to was closer to 15 or 16%. And what the Supreme Court effectively said, and I'm no maths expert, by the way, I make that point very, very firmly at this stage, but I sort of follow the point. If you are doing significantly fewer days than a full-timer, so if your work pattern is maybe 1 or 2 days here or there and a lot of time off for leave, which of course in the Harper Trust case meant a lot of weeks because the school was closed, then it's very unlikely that 12.07% would come close to being an accurate reflection of the pay that you're entitled to for the leave. What the Supreme Court said was that it's only in cases where someone is working very close to or full-time during that period that 12.07% becomes a more accurate calculation. So those are the two principles. You will all then say, quite rightly, as did I, and as did many of my colleagues who work in this sector, well, that's not very helpful because you're dealing all of the time with atypical workers, you're dealing all the time with people who do not have normal hours. And what the Supreme Court have now done, certainly with the 12.07% ruling, is they've injected an air of significant uncertainty into an area that previously everybody felt was quite certain. So there was uproar, and the government recognised there was some uproar and decided to have a look at it. It went away, contemplated its navel, did some consultations, and rather surprisingly, because most employment lawyers were expecting the consultation to last a lot longer than it did, rather surprisingly, just before Christmas, they announced they were going to introduce some legislation which would remedy or deal with this uncertainty. What they wanted to do was bring back some certainty in relation to atypical workers. And if, Katie, we can move on to the next slide, we'll get to the crux of today's presentation. They brought forward some draft regulations, as always, a bit of a mouthful, the Employment Rights Amendment, Revocation and Transitional Provision Regulations 2023. They brought those forward at the end of last year. And the reason for the timing was that the government, you might remember, were also trying to deal with exiting the EU and removing some regulations or amending some regulations and legislation that was based on EU law, and they were trying to do that before the end of 2023. So they took this, or they took that rather, as an opportunity to introduce these new provisions, which do, I think, or I hope, when we go through some of the flowcharts, bring some certainty back to how we calculate leave and pay for that leave for atypical workers. So the regulations came into force on the 1st of January of this year. They only extend to England, Wales and Scotland. Northern Ireland will have to think about what it wants to do. It's likely, I think, to follow suit, but the reason there's a delay is you'll all remember that the Northern Ireland Assembly was suspended for a significant period. No legislation was going through there, so they're very much behind in terms of playing catch up with what's happened in England, Wales and Scotland. The regulations apply to all workers, and workers is the very wide definition that's used to cover agency temps on contracts for services and ordinary employees. And of course, some agency temps are employees. I'm thinking particularly of umbrella workers. Umbrella workers are historically employees on contracts of employment with the umbrella companies. But workers is the catch-all category, and the new rules apply across the piece to both workers and employees. The rules don't apply, and indeed the rules relating to holidays and holiday pay have never applied to the legitimately self-employed. Legitimately self-employed individuals have no right, never have had, and continue not to have any rights to paid annual leave under the working time regulations. And what these new provisions do, as I say, is they try, and I think successfully, rectify some of the problems that the Harper Trust and Brazel case gave rise to. So let's move on to the next slide, please, Katie, if we could. Now, I'll make a point before I talk to you about these two rather wordy definitions, that what these regulations don't do is just remedy the discrepancies in the law that Harper Trust and Brazel highlighted. They do go a little bit further. And Marie said right at the start that some of the rules and regulations under these new regulations apply to everybody who's entitled to paid annual leave, not just these two groups. So I make that as a sort of preamble or preliminary point before I launch into these definitions. The principles that I'm going to talk about a little bit later, however, do only apply to these two categories of worker. The principles I'm going to talk about in relation to paid annual leave and the calculation of that leave, and indeed rolled up holiday pay, which we'll come on to, they only apply to these two categories. They do not apply to anyone who falls outside these two categories. So that's very important to note. So when you're considering the new rules that we're going to talk about, you first of all have to establish whether or not the person that you're going to apply the new rules to falls into either or other of these categories. They don't have to fall into both. One or the other will do. But if they don't fall into either of these categories, then the rules that we're going to talk about simply do not apply. The rules that did apply before these new regulations came in will continue to apply to those workers. So what are these two categories and what are the two definitions? Well, as always, the legislation tends to be a little bit wordy, doesn't it? But we're dealing with irregular hours workers and part-year workers. And an irregular hours worker, or maybe I'll just read the definition of a worker, the regulations say, is an irregular hours worker in relation to a leave year if the number of paid hours that they will work, that will, I think, is very important, if the number of paid hours that they will work in each pay period during the term of their contract in that year is, under the terms of their contract, wholly or mostly variable. So if someone only does a very small percentage of variable hours, they won't satisfy the definition because those hours are not wholly or mostly variable. And interestingly, there's an element of crystal ball gazing, isn't there, in this definition? I highlighted the word will. The definition says that someone is a irregular hours worker if the number of paid hours that they will work in each pay period during the term of their contract is wholly or mostly variable. It might be at the start of the contractual relationship that it looks very obvious to everybody, to worker and employer, that those hours are going to be wholly or mostly variable. And that will probably be sufficient for the purposes of this definition, because even if it turns out that they're not in fact wholly or mostly variable as the year progresses, the fact that at the start of the year, it seemed obvious to everybody that they were going to be, that will be sufficient for the individual to be treated as an irregular hours worker. Or at least that's my best guess as a relatively well-informed employment lawyer. But I think it's very interesting that that word will is included in the definition. So that's an irregular hours worker. And if you've got an individual on your books who satisfies that definition, the new rules that we're about to come on to talk about will apply to them. The new rules that we're going to come on to talk about also apply to part-year workers. And Mrs. Brazel, if you ever have insomnia and you want to go away and read the Supreme Court's decision in all of its glory, you will find out that Mrs. Brazel satisfies this definition. So the part-year worker definition is effectively a homage to Mrs. Brazel because she was the personification of this definition. So what is it? Well, a worker, it says, is a part-year worker in relation to a leave year if under the terms of their contract, they're required to work only part of that year. Well, that was the case for Mrs. Brazel because she was only required to work when school was actually open. So they're required to work only part of the year, and there are periods within that year during the terms of the contract of at least a week which they're not required to work and for which they're not paid. Now that again fits Mrs. Brazel's situation perfectly. She was a peripatetic music teacher, and there may well have been weeks when no children required any music lessons. And that would be a week when she wasn't required to work and a week when she wasn't paid. So Mrs. Brazel satisfies that definition. And if you're a part-year worker, if you have a part-year worker on your books, then they will benefit from the provisions that we're going to come on to talk about. So, sorry we spent a long time on that one slide, but that's a very, very important slide because it's the necessary preamble to everything that we're going to mention now. So, Katie, we could move on to the next slide, please. I said that these new regulations applied from, came into force, I've got to be careful with my own words, came into force on the 1st of January, but they only apply to leave years that begin after the 31st of March this year. Now, what does that mean? Well, what that means is if you have a leave year that started on the 1st of January 2024, so 1st of January to 31st December, these new rules don't apply to you. These new rules will only apply to you when your holiday year next year starts. So these new rules will only apply to you from the 1st of January 2025. Yeah. If, however, your holiday year this year started on the 1st of May, let's say, and it runs from the 1st of May to the end of April, these new rules applied to you from the 1st of May. So that's the importance of that 31st March cutoff point If the leave year started before the 31st of March 2024, these new rules only apply to you from the start of your next holiday year. Yeah. If your leave year started after the 31st of March 2024, then these new rules will currently apply. So, of course, you're in your new leave year. If you've got a leave year that starts rather bizarrely on the 1st of August, then these rules don't apply yet, but they will apply as at the 1st of August. So what does that mean? That means that we've got two schemes effectively running in parallel, because we've got some workers who don't benefit from these new rules, who still have to have their holidays and holiday pay calculated by reference to the old rules, so the Working Time Regulations rules and the Employment Rights Act rules, subject to some changes which these regulations do make to everybody, which I'll come on to in a second or two. And then we have a second group of people where these new regulations apply, who will have their holidays and holiday pay calculated by reference to those new rules. That's a rather unsatisfactory state of affairs, it seems to me, but we will get to a point where everybody, if they are an irregular hours or part-year worker, everybody will be treated in exactly the same way under these provisions. But again, that's an important point to make. 31st of March cut-off point, and those are the implications for that cut-off point. Okay, can we move on to the next slide, please? Now, what I've done here is used what I think, well, what I hope at least is a helpful flowchart. Quite like flowcharts. They do have a habit of simplifying what are pretty complicated issues. Now, on this flowchart, there are going to be a couple of concepts that we've not yet touched on. But what I just wanted to do is take out some of this flowchart and talk you through it, because a question we get regularly asked is, how do we calculate holidays and holiday pay when someone is absent from work, normally on the grounds of ill health, or perhaps they're taking some other type of leave, as long as it's not holidays. So if we start at the top of the flowchart, the first question you ask yourselves is the individual off work, sick, or on statutory leave? Let's just talk about what happens down the left-hand side of this flowchart for the moment, because this is really the only point I want to make. But the flowchart is useful for you to have in any event. So if they're off work, sick, or if they're on some other form of statutory leave, which is an annual leave, then you'll see that the flowchart makes the point that they continue to accrue holidays based on the following formula. And this is where we have the 12.07% reintroduction following the enactment of these regulations. So the formula is 12.07% of the average hours worked in the 52 weeks before that sickness or statutory absence commenced, including any weeks where no work's done, but importantly, excluding any weeks where that person has been sick or on statutory leave. So that's the formula for calculating the amount of holiday that has accrued in a pay period for someone who is sick or on some other form of statutory leave, but only if they are a part-year or an irregular hours worker. That's the formula that's used. And the reason I'm highlighting it at this stage is because there's been a lot of confusion over which weeks count. And you'll see from the flowcharts that you include weeks where no work was done, but you exclude weeks where the person has been sick or on statutory leave. Okay. What I'll do is I'll leave that there. We may come back to it later because I want to talk about the broad concepts that the regulations have introduced. So I've got slightly ahead of myself with this slide, but I wanted to just make the point that there are some special rules where people are absent due to sickness or on some other statutory leave. So Katie, we can move to the next slide. How do we then calculate holiday entitlement? And there are two concepts. There's holiday entitlement, and then there's holiday pay. And the two are obviously related, but they're very different. And a lot of clients I talk to confuse the two. They talk to me regularly about holiday pay, when in reality they mean holiday entitlement. And it's important to get the two very clear. The working time regulations give an entitlement to leave. They actually don't give an entitlement to pay. What they say is you have an entitlement to annual leave, and that annual leave has to be paid. And the working time regulations say you should be paid a week's pay for each week's leave. The fundamental right under the working time directive is to time off. It happens to be paid time off, but it's to time off. And it's the first time that European workers were ever given a statutory right to not work, to take time away. It's ostensibly a health and safety measure. So we're dealing with the right to paid leave. And for irregular hours and part-year workers only, we've got a method which is being colloquially called the accrual method. And the way you calculate how much leave someone who is an irregular hours or part-year worker is entitled to is by calculating 12.07% of the hours that they've worked in a pay period. If you've got a worker, and most temps are paid on a weekly basis, so let's just focus on them for a second. If you've got a worker who is paid weekly, then you calculate the entitlement to paid leave that they have accrued by reference to the hours they worked in that week. So you tot up the number of hours they've worked, you multiply the number of hours by 12.07%, and that is how much annual leave they have accrued in that week. If they're paid monthly, you do the same calculation at the end of the month. So you look at the number of hours that they've worked in the month, you multiply it by 12.07%, and that's the annual leave that's been accrued by that worker in that pay period.
Excellent. Looks like we have a connection issue here. I think, Paul, are you there? Paul, can you hear us okay?
I can hear you. Can you hear me?
Yes, I can now. Yep, I think you just froze. We lost a bit of connection then.
I'm going to turn my video off, Maria.
Okay.
If that works. Okay, so I don't know how much of that you lost, but I'll start again. If you're an irregular hours worker or a part-year worker, you have to you have to have your holiday accrual calculated at the end of each pay period. So you look at a weekly paid worker, you look at the hours they've worked in the previous week, you multiply it by 12.07%, and you get the number of hours that they have accrued in that pay period. If they're paid monthly, then you do the same calculation for the month, and you apply the 12.07% calculation. Fractions are rounded up if you get to 30 minutes or more. Fractions are rounded down if you get to less than 30 minutes. And the important point to note here that for irregular hours and part-year workers, they can only demand the holiday that they have accrued and any that might have been carried over. But I'll leave that. That complicates matters. Let's assume they've not carried over any leave. They can only demand to be paid for the amount of paid leave that they have accrued under this scheme. So let's say someone's accrued 50 hours worth of leave, but they want to take 75 hours worth of time off. They would only be entitled to be paid for the 50 that's accrued. It will be down to the discretion of the employer to decide whether or not they were paid for the additional 25 that they want to take. But they can't demand to be paid for that additional amount if they haven't accrued it. And the final point to make about this slide is if the worker doesn't meet the definition of an irregular hours or a part-year worker, then they continue to accrue holiday entitlement in line with the working time regulations and the Employment Rights Act as they have historically accrued it. These provisions only apply to irregular hours workers and part-year workers. So you can see it's actually quite simple, because this calculation determines the amount of time someone can take off, doesn't determine the amount that they're paid for it, which we'll come on to in a second, but it determines the amount of time that they can take off. And then once you've worked out how much time they can take off, you then apply the normal week's pay for a week's leave rules, and that gives you the amount that they're then due to be paid for the time that they take. Katie, could we move on to the next slide, please? Said at the very start that these regulations don't just introduce this concept of irregular hours and part-year workers. That's the central thrust or the central theme of them, but they do deal with some other issues. And what I wanted to cover off now is the changes that have been made for those who don't have normal hours, for those who do have normal hours, or those who are not irregular hours or part-year workers. Next slide, please, Katie. Thank you. So we've talked about how we calculate how much leave someone's entitled to if they're irregular hours or part-year worker. They're then entitled, as indeed every worker is, whether they're irregular hours or part-year, they're then entitled to a week's pay for a week's leave. And at the very start of today's presentation, Marie made the point that this is a very important concept, because this definition, or this reconfirmation of a definition which has been affected by case law over the last 10 or so years, is very important, because it doesn't just apply to irregular hours or part-year workers, it applies to everybody who is entitled to paid annual leave under the working time regulations. So that's all workers, all temporary workers, all workers on contracts of employment, but excluding those who are self-employed. So if you're entitled to paid annual leave under the working time regulations, then this definition of a week's pay is very important. And the legislation makes it clear that there are certain elements that need to be included when calculating a week's pay. And in fact, before we started today's, I think I might have I dropped again, Marie? Am I back? Sorry, I've looked.
Yeah, you're still there, you're fine.
Okay, excellent, fine. So we, Marie and I had a little chat before we started today around all of this, because questions had been raised in relation to commission payments. And I said that I would endeavour to be as clear as I could based on my understanding of the regulations. Just to sort of set the scene here, there's been a lot of case law around what should or shouldn't be included in the calculation of a week's pay for a week's leave. Most of it has been driven by the European Court of Justice, and that, of course, is still relevant even now that we're not part of the EU. And the whole series of cases started with a case called Locke against British Gas. The principle here is that people shouldn't be disincentivized to take annual leave. And in the Locke and British Gas case, Mr. Locke was, the court said, disincentivized because when he took leave, there were elements of his pay that weren't included in the calculation of a week's pay for a week's leave. So effectively, when he took a week's leave, he earned a lot less or was paid a lot less than he would have done had he stayed at work and continued to perform services for his employer. And he put his hand up and said, that's just not appropriate. That must be wrong. I shouldn't be disincentivized or penalized when I take my leave. I should receive the same pay that I would have received had I continued to work. And I'm paraphrasing years' worth of cases here when I say this, but in very, very broad terms, the courts have agreed with that principle. They've looked at it and said, paid annual leave is a health and safety entitlement. You need to take the time off. So when you do take the time off and you're paid for it, you shouldn't be any worse off than you would have been had you continued to work. And I think if we attack the next slide, or this slide rather, with that principle very firmly at the forefront of our minds, we'll see why this legislation reaches the conclusions that it does. So these payments have got to be included when you determine what a week's pay is for a week's leave. Legislation is very clear. It says payments, including commission payments, and this is the generic bit, which is very important, which are intrinsically linked to the performance of tasks which a worker is obliged to carry out under the terms of their contract. Now, specifically commission payments are mentioned, but it's not just commission payments. Any payments that are made to someone which are intrinsically linked to the work they do or the performance of tasks which they undertake should be included. So again, Marie and I at the start of this today talked about someone who was a piece worker, for example, someone who gets paid by reference to the amount of items that they produce. Let's say they're on a production line and they're producing widgets. If they produce 1,000 widgets in a day, they get paid X. If they only produce 500 widgets a day, they get paid Y. So they might get a base salary, but on top of that, they then get an incentive payment to produce more widgets. That's very much, piece work is very much like commission. So if you've got a consultant, for example, you are saying to them, here's your base salary, but here's a commission scheme. And the commission scheme that applies is designed to encourage you to bill more from your clients. And if you bill more from your clients, you will then take home more pay. We're trying to incentivize you to generate more business for the firm. So commission payments are included in the definition, and other payments that are intrinsically linked, as outlined, will also be included. But there are other payments mentioned in the legislation as well, payments for professional or personal status relating to length of service, seniority, or professional qualifications. So, for example, if you had a consultant who had been put forward for the REC's exam and they passed the REC's exam, and you would normally give someone a pay rise for passing the REC's exam, that will also be a payment that needs to be included. You may give your employees a service-related increase. So if they've been with you for 10 years, you bung them either a one-off payment or you increase their salary. Equally, you might give them a performance-related payment. Am I still with you, Marie? Because my internet connection says it's unstable. I'm still with you. Okay. You might give them a competence or performance-related payment. If you have a performance management process, for example, and they're ticking all of the boxes, getting 10 out of 10 each time, you might have a scheme that says, well, as a result of getting 10 out of 10 for the last 3 years on the trot, we're going to increase your pay or give you a one-off payment. So all of those types of payments have to be included in calculating a week's pay. But there's a huge catch-all category as well, which again is designed to follow the case law. Other payments, such as overtime payments, which have been regularly paid to a worker in the 52 weeks preceding the calculation date. Now, this is a great phrase for lawyers because there's an enormous amount of uncertainty over what constitutes a regular payment. There were a lot of discussions or have been a lot of discussions over recent years as to overtime, whether overtime should be included. There were differences between guaranteed overtime, voluntary overtime, non-guaranteed overtime. This legislation has effectively done away with those distinctions and has said that any overtime payments, whether they be mandatory, voluntary, or otherwise, that have been regularly paid to a worker in the 52 weeks before the calculation date, then they need to be included. I think there is going to be some litigation over what constitutes regular payments and how regular does it have to be regular. So watch this space. There may well be some claims brought by individuals asserting that their overtime payments, for example, were regular, but for some reason their employers not included them in the calculation. So a very important slide, and the next one is also as important, because what I want to do here is make it clear what these new rules relate to, because again, there is some confusion. So in the working time regulations, we've got regulation 13, which gives people the entitlement that the working time directive originally gave to all European workers, entitlement to 4 weeks paid leave each leave year. And believe it or not, that was our only obligation. Our only obligation was to give everybody 4 weeks paid leave. But the government at the time decided actually we wanted to do better than that, and we wanted to gold plate the European entitlement. So we introduced regulation 13A, which gives people an entitlement to a further 1.6 weeks. And when you add 4 and 1.6, you get the figure that everybody's very familiar with, 5.6 weeks. But as a result of those two different entitlements under two different regulations, the rules that we are talking about now, the government did have an opportunity, by the way, before bringing these new rules in, to equalise the treatment of those two periods. So to make the treatment of 4 and 1.6 the same. For some bizarre reason, it decided not to do that. So we're still in a position where we've got regulation 13, i.e. 4 weeks paid leave, and regulation 13A, the additional 1.6 weeks paid leave. And the rules that relate to both are different. Now that's, on the one hand, unhelpful, but on the other, potentially helpful if you have people who, well, you'll have everybody on 5.6 weeks, but you may decide that you want to treat them slightly differently, or you want to treat the additional 1.6 weeks annual leave slightly differently, and you are entitled to continue doing that. You've always been entitled to do it. Nothing in these new rules requires you to treat the 4 and the additional 1.6 weeks paid leave in the same way. So everything I have talked about so far in relation to 12.07% and what should be included in a week's pay for a week's leave only applies to the regulation 13 leave and not the additional 1.6 weeks paid leave under regulation 13A. So what that means is, yes, you have to include everything on the previous slide when calculating a week's pay for a week's leave, but you only have to do that for the first 4 weeks for the regulation 13 leave. You don't have to include all of those elements for the additional 1.6 weeks paid leave. And what we've had from clients for a number of years, and I suspect will continue to have until the government decides that it's appropriate to equalise the two treatments, is we've had clients who have taken advantage of that discrepancy. So they've made a particular payment which includes the elements that we've just described for the 4 weeks, and they've simply paid basic pay, and they've not included anything like overtime or commission or any of the other elements that were on the previous slide. They've not included those in the additional 1.6 weeks paid leave under regulation 13A. And I wanted to make the point at this stage in the discussions, I wanted to make the point that that is perfectly legitimate. And it could help those, for example, who are concerned about including commission in the calculation of paid leave. You have to include commission for the first 4 weeks, but you do not have to include commission for the additional 1.6. And of course, by logical extension, if someone gets more than 5.6 5.6 weeks paid leave per year, and there are lots of employers who give their employees and their workers more than the statutory minimum, because 5.6 is simply the statutory minimum. If you get 6 weeks or 6.5 weeks annual leave, it's only the 4 weeks under Regulation 13 that's subject to these rules. Anything over and above 4 weeks, you can decide to pay in a different way. So I hope that's clear, because we are only here talking about the 4 weeks under Regulation 13. The next slide, please, Katie, brings in the second new concept. Some of you may be scratching your head when I use the word new, because a lot of you will have been paying rolled up holiday pay for years and have thought nothing about it. But if I tell you that you've been doing so unlawfully, you may wonder what on earth I'm talking about, but you have. Take it from me, you've been paying rolled up holiday pay unlawfully. Now, there are a whole series of cases and rules around how paying rolled up holiday pay will allow you to take advantage of any proper enhancement over the basic rate. But for those of you who don't know what rolled up holiday pay is, it's a basic rate, let's say, of £15 an hour and a further £2.50, let's say, I'm just plucking random figures from thin air, £15 an hour plus a further £2.50 for every hour that's worked, added together £17.50. That rate includes holidays, or a payment in advance for holidays. And when the person then takes their leave, the employer then says, but you're not entitled to any further pay. You've already had it. It's been included in your rate. The government, surprisingly, when they consulted over this, asked people to think about rolled up holiday pay. And I think a lot of people thought the government would leave it alone, because, again, when we're talking about health and safety legislation and disincentives to take leave, rolled up holiday pay is a huge disincentive potentially for someone to take leave. Why would they take the time off when they get paid for the holiday in advance and they don't have to take the holiday to get the pay? The government surprised everybody by making the point in the new legislation that for irregular hours and part-year workers, and only for those two categories, not for anyone else, for irregular hours and part-year workers only, it is possible to roll up the holiday pay into the hourly rate, and they're effectively therefore making years' worth of unlawful activity lawful moving forwards. But don't take this as a green light to introduce rolled up holiday pay for everybody. As I say, it's only for irregular hours and part-year workers. You've got a basic, or the additional element, you've got to base that on total earnings in the pay period. So you've got to take into account everything they've earned if they're a weekly paid worker in the previous week. And you've got to base the rolled up element on that. And can you still hear me? Excellent. The calculation is 12.07%, assuming, of course, we're talking about 5.6 weeks. That was one of the other questions, I think, that was sent in advance, whether or not 12.07% was fixed. 12.07% is fixed for the purposes of 5.6 weeks statutory minimum leave. If you're going to roll up holiday pay for someone who has a greater entitlement than 5.6 weeks, then that percentage will increase. So you'll have to revise the percentage. The jury's out on whether or not having a higher percentage in those circumstances where someone's entitled to more annual leave than 5.6 weeks is still in compliance with the legislation. There's nothing that says it isn't, but I think I'll be interested to see what the courts say about it, because the legislation only talks about 12.07% as an uplift in this type of case where the holiday is rolled up, or as a way of calculating annual leave for those with 5.6 weeks entitlement. So I can't say for certain that you will be able to increase the percentage, but logic dictates that if people have more holiday entitlement, the 12.07% doesn't work, because it's a lower percentage than, for example, 6.5% 6.5 weeks would be of 52 weeks. That's how we get to 12.07%. That's the percentage of 5.6 weeks of 52 weeks in the year. To pay rolled up holiday pay, you've got to do what it says on the tin. You've got to pay it at the same time as the individual's paid for the hours they work. You can't defer it. You've got to pay it at exactly the same time. We've got different rules, and I've touched on that previously, haven't I? We've got different rules in relation to sickness and sickness absence and how you make the calculation. And that's something we might have to take offline if there are any specific questions on it. And then you've got to itemise the enhancement, so the rolled up element on the pay slip. The workers have got to see very clearly what their base rate is and what the enhancement is for the advanced holiday pay. That's got to be set out on the pay slip. And I want to, with the final item on this slide, very quickly just dispel myth that the workers can demand it. The slide's actually slightly incorrect when it says request. Workers can, of course, request it. What I really meant to say was workers can't demand it. So an irregular hours or a part-year worker cannot bang their fist on the table and say to you, the employer, I demand rolled up holiday pay. They can do that, but you can ignore them. It's a business decision for you as to whether rolled up holiday pay is the best course of action. You may decide it is, equally you may decide that it isn't. If it is, you've got to comply with these rules. If you decide it isn't, that's the end of the argument. Okay, can we move on to the next slide? Because I'm conscious that I've thrown lots at you, and I'm conscious that to some extent, it's incumbent upon me to try and draw in all of the threads. And I think that's what this flowchart, well, I hope that's what this flowchart does. So I'm going to take you through it very quickly. I'm conscious we're running out of time, but I do think it's worthwhile just having a look at this. When we circulate the slides, I'm just going to add an extra little box at the bottom, which got missed off when these slides were devised in the last couple of days. So you will have the box that's missing. So we start with the first question: is the individual an employee or a worker? Well, if they're not, if they're self-employed, they have no paid holiday entitlement. If they are, you then ask the question, are they in irregular hours or a part-year worker? Now, if they're not in irregular hours or a part-year worker, you then ask the question, does their pay fluctuate? And again, Maria and I had a bit of a debate about this at the start of today's proceedings. I take the view that someone who is paid commission, who is not in irregular hours or a part-year worker, someone who's paid commission will be someone whose pay fluctuates. It fluctuates because that commission will change. It could be zero in one pay period. It could be £1,000 in the next. It could be 3,000 in the pay period after that, but their pay fluctuates. If their pay fluctuates, then you'll see from the right-hand side of the flowchart that their 4 weeks paid leave under Regulation 13 should be paid at the rate of a week's pay to include the fluctuating elements, i.e. the commission, and the additional 1.6 weeks under Regulation 13A can be paid at basic pay if you so wish. If their pay doesn't fluctuate, then you'll see from the flowchart that Regulation 13 and 13A leave should be paid at the rate of their normal pay, which will be their normal pay set out in their contract of employment. So let's say you've got an ordinary employee who isn't an irregular or part-year worker, who doesn't have fluctuating pay, they're just paid effectively a salary, then their 4 plus 1.6 weeks paid leave entitlement should be paid at the rate of a week's pay, which will be set out in their contract. It will be their salary divided by 52. Okay, if they're an irregular, so we go back up the flowchart now. If they're an irregular hours or a part-year worker, then you'll see that their holiday entitlement, as we've described, accrues at the rate of 12.07% of the hours that they work in each pay period, with those slight discrepancies for sickness or statutory leave. The question then is asked, do you want to roll up their holiday pay? If you do, you can, but you've got to satisfy the requirements that we've outlined. If you don't want to pay roll-up holiday pay, then you'll see the very bottom box describes what should happen. Each time the worker takes a period of holiday, you need to work out the holiday pay that's due to them by taking an average of all the pay that they've received. That's everything on that slide that said what is a week's pay. An average of all pay received in the 52 weeks prior to taking leave. But in calculating what constitutes those 52 weeks, you exclude weeks when there's been no work done and any weeks on statutory or sick leave. And you look back to earlier weeks worked in those cases to get to 52 weeks from which an average can be taken. So if they've been with you for 2 years, you can look back to a maximum of 2 years. You can look back over 104 weeks to get to your 52 weeks if you have to exclude a number of them. The question people regularly ask is, yeah, well, what happens if someone's not been there for 52 weeks? Well, you take the period they have been there. You clearly can't work back any further than 52 weeks. So the averaging period is the number of weeks that they've actually worked. But if it's 52 weeks or longer, you can go back 52 weeks. Now, that flowchart I actually think is quite helpful. And when the slides are circulated, I'll add in the final box, but it doesn't change anything. It just adds a little bit more detail. So I hope you found that helpful. The very final slide, which I'm conscious we probably haven't got time for, so I'll just mention it very briefly. There were some other changes in these regulations that no one really noticed. There were a lot of rule changes around holidays and the rolling forward or the carrying forward of leave during the COVID-19 period. Effectively, and I'm paraphrasing here, those old rules are now defunct. And on that note, Marie, conscious I've taken up the full hour, I'm done.
Thank you, Paul. To be honest, you've had me gripped from the first part in terms of all the information. So it's been really well explained, and I love the flow diagrams. I think that's going to be super helpful when we share the slides and the video of this webinar to those that attended. So thank you so much for that. We have got a handful of questions, but I'm conscious of time. So what we'll do is we'll follow up separately with those questions to the individuals. I think ones that you've already actually answered anyway, Paul, which was around the split in between the 4 weeks and the 1.6 weeks. So my understanding is that 1.6 weeks of holiday pay would be the employee's base salary per their contract, not say minimum wage or anything like that.
You've got, yeah, you've got a lot more flexibility, I think, is the thing to take away from that in relation to the additional 1.6 than you have in relation to the 4 under Regulation 13, yeah.
Yeah, but it's what's included in their contract that is what you pay them, not minimum wage or anything like that. So I think that question was answered anyway. But in terms of the other questions, we'll get back to you separately on that. But yeah, I just want to say a massive thank you, Paul. You've explained that so well. And interesting to hear about the Harper Trust case, because I've read up on it before, but actually that was my old school that I went to.
Oh, okay.
So it's quite interesting to see if they've made the press on that. But yeah, thank you to everyone who attended today. I hope you found that very interesting. Can
I just very quickly make my plug?
Oh yes, of course.
So,
yes.
Very, very quickly for anyone who's interested, if you would like a holiday pay policy that complies with everything I've talked about today, written in very understandable English, we are selling those to people who are on this webinar at the cut price discount value price of £250 plus VAT. So if you're interested in that, please drop Marie or her colleagues a line and we'll be in touch on that. But thank you very much. Perfect, Paul. Thank you. We'll include that offer on the follow-up email that we send out to all those that attended this webinar. And also just to say as well, in regards to holiday pay, we do have a margin calculator on our recruitment accountants website that's free to download, that can help you in terms of setting your margins and take into account that holiday pay element as well. So please take a look at that on our website. Hopefully that's useful. We will follow up with Paul's contact details and my contact details. So if you do want to get in touch and if you've got any further questions or anything, I'm sure Paul will be more than happy to answer those. So we will be doing more webinars, so please keep an eye out for the emails and things and social media posts that we share. But that's it from us today. So I just want to say thanks very much, Paul, for joining us, and thank you to you for joining us today, and enjoy the rest of your day. Hopefully the sun will be out. All right. Thanks very much, Paul.